Constitutional Court Interpretation Number 582, Cross-Examination of a Co-Defendant's Case. Issue: Are the relevant precedents holding that a statement made by a criminal co-defendant against another co-defendant may be admissible without cross-examination unconstitutional? Holding: Article 16 of the Constitution guarantees the people's right to judicial remedy. As far as a criminal defendant is concerned, such guarantee should also include his right to adequately defend himself in a legal action brought against him. A criminal defendant's right to examine a witness is a corollary of such a right, which is also protected by the due process of law concept embodied under Article 8 of Paragraph 1 of the Constitution, providing, among other things, that no person shall be tried and punished otherwise than by a court of law, in accordance with the procedure prescribed by law. In order to ensure the defendant's right to examine any witness during a trial, a witness should appear in court and sign an affidavit to tell the truth in accordance with the relevant statutory procedures. And it is not until the witness is confronted and examined by the defendant that the witness statement may be used as a basis upon which decision as to the defendant's criminal culpability can be made. The situation of a criminal co-defendant exists due to efficiency concerns as a result either of the merger or addition of complaints filed by the public or private prosecutor or the mergers of trials initiated by the court. The respective defendants and the facts related to their respective crimes, however, still exist independently of each other. Therefore, a co-defendant is in essence a third-party witness in a case concerning another co-defendant. Thus, the merger of cases should not be affect the aforesaid constitutional rights of such other co-defendant. It has been held in criminal precedent of the Supreme Court that 31 Shang 2423 and the Supreme Court Criminal Precedent 46 Tai Shang 419 that a statement made by a co-defendant against himself may be admitted into evidence supporting the crime to the determination of the facts related to another co-defendant. Such holding has failed to treat a co-defendant as a witness in making a statement during the trial against another co-defendant, but instead, it has admitted the co-defendant's statement into evidence against such other co-defendant merely because of his status as a co-defendant. In doing so, the holding has denied a co-defendant the standing as a witness in a trial for another co-defendant, and thus failed to follow the statutory investigative procedure as to the witness. Hence, it is in breach of Article 273 of the Code of Criminal Procedure as amended and promulgated on January 1st, 1935, and has unjustly deprive such other co-defendant of the right to examine the co-defendant who should have held standing as a witness. We therefore are of the opinion that such holding is inconsistent with the constitutional intent first described above. Those portions of the opinion as detailed given in the aforesaid two precedents as well as other precedents with the same holding, which are not in line with the intent described above, should no longer be cited and applied. Under the constitutional principle of due process of law, the principle of judgment per evidence and voluntary confession have been adopted as the determination of criminal facts in a criminal trial. Accordingly, the Code of Criminal Procedure has adopted the doctrine of strict proof, under which no defendant shall be pronounced guilty until a court of law has legally investigated admissible evidence and achieved firm belief that such evidence is sufficient to prove the defendant's guilt. And in order not to give undue weight to confession, thus negatively impeding the discovery of truth, the protection of the human rights, and the said Code also provides that the confession of an accused person should not be used as the sole basis of a conviction, and that other necessary evidence should still be investigated to see if the confession is consistent with the facts. In light of the foregoing doctrine of strict proof and strict restriction on the probative value of confession, that is, to restrict the probative value of confession, such other necessary evidence, such quoted unquoted other necessary evidence, must also be admissible evidence that should be legally investigated. Besides, as far as the probative value is concerned, the weight of confession is not necessarily stronger than that of such other necessary evidence, which should not be considered only secondary or supplemental to the confession and hence weaker, flimsier. Instead, the confession and other necessary evidence should be mutually probative of each other, leading to a firm belief after a thorough judgment that the confessed crime is confirmed by such other necessary evidence. Supreme Court Criminal Precedent 30-3038, Supreme Court Criminal Precedent 70 5638, and Supreme Court Criminal Precedent 74 103 were intended to elaborate on the meaning, nature, scope, and degree of proof for other necessary evidence, as well as its relationship with the confession. Furthermore, these precedents also stress that such evidence should corroborate the truth of confession, so that the confessed crime can be established beyond reasonable doubt. We therefore are of the opinion that these precedents, as well as other precedents with the same gist, do not run afoul of the constitutional intent first described above. This court has repeatedly issued interpretation to the effect that a final and conclusive judgment should be deemed as an order, and subjected to the judicial review if any precedent is cited and invoked in reaching the judgment. The petition at the issue concerns a final and conclusive criminal judgment, namely Supreme Court Criminal Judgment 89 Taishang 2196. Though the judgment did not formally specify the reference numbers of the aforesaid 5 interpretations, it did describe in the reasoning that the criminal facts regarding the petitioner were determined and sustained by the judgment rendered by the court of second instance. Such facts were all established by the confession given by the co-defendants of the petitioner at the time of interrogation conducted by the police or prosecution, as well as parts of the confession given at the appellate trial. That such confession were consistent with the circumstances surrounding the kidnapping and the ransom, stolen cars alleged by parents of the victim to the offense of the kidnapping for ransom, and the victim to the offense of theft, and the other witnesses also testify unambiguously as to the course of the crime committed by petitioner and the co-defendant. That the judgment were also based on additional material evidence and documentary evidence attached to the case file. And the court of second instance, in addition to hearing the foregoing confession of the co-defendant, had also done everything in its power to investigate any other essential evidence related to the offense alleged committed by the petitioner. The foregoing, in our opinion, is in line with the 5 precedents cited in the petition at the issue, both in form and in substance, which apparently signify the aforesaid judgment has cited and invoked the precedents at the issue as the basis for its decision. Since the petitioner has considered such precedents to be unconstitutional, they are unquestionably subject to review by this court. Therefore, under Article 5, Paragraph 1, Subparagraph 2 of the Constitutional Code Procedure Act, this petition should be accepted. Article 16 of the Constitution provides for the people's right to judicial remedy. As far as a criminal defendant is concerned, he should enjoy the right to adequately defend himself under the confrontational system according to the adversarial rules to ensure a fair trial. The right of an accused to examine a witness is a corollary of such a right. As early as July 28, 1928, Article 286 of the then effective Code of Criminal Procedure, as well as the subsequent amendment to the Article 273 of the same code, promulgated on January 1st, 1935, already provided that upon the conclusion of the questioning of a witness or an expert witness by the presiding judge, the party concerned or his defense attorney may file a motion with the court to have the presiding judge examine such witness or expert witness or to examine the same directly. Paragraph 1. If a witness or an expert witness is called to testify by means of a motion, he shall first be examined by the party calling him or the party's defense attorney, then cross-examined by the counterparty or the counterparty's defense attorney, and then re-examined by the party calling him or the party's defense attorney, provided that the redirect examination shall be limited in scope to the matter revealed during the cross-examination. Paragraph 2. Subsequently, Article 166 of the Code of Criminal Procedure as amended and promulgated on January 28, 1967, preserved the same provision, and more detailed provision were adopted to the said code when it was amended on February 6, 2003, namely Article 160 through Article 167-7 thereof. Such right of a criminal defendant is universally provided, whether in a civil law country or a common law jurisdiction, and whether an adversarial system or an inquisitorial setting is adopted in administering the state's criminal justice system. Apparently, it is the universal and fundamental right of an accused to examine a witness. Apparently, it is universal and fundamental right of an accused to examine a witness.